The Honourable Christopher Finlayson.
Thank you, sir. I just want to take a brief call to discuss the possible application of the Bill of Rights Act 1990 to this legislation. So I'm doing it as Attorney General. Normally the obligation of the Attorney is to produce a Section 7 report if an issue arises, but I've thought long and hard about the matter I want to discuss and have concluded that the Bill of Rights Act does not apply. But because it's an important issue, I thought I'd take a brief call to highlight it for members of the Select Committee who in due course will be looking at the bill if it goes there. As has been stated by the Minister and the previous speaker, the bill's going to amend certain provisions of the Maori Purposes Act 1991 relating to the Wiperi Trust. One aspect, and the aspect of the bill that caused me to think long and hard, was the issue of possible discrimination on the grounds of family status. As things stand under the Maori Purposes Act 1991, beneficiaries of the trust are treated differently according to whether they're lineal descendants of Wiperi or descendants as a result of adoption. Those related by blood may inherit a parent's beneficial interest in the trust and in turn pass that interest to their own children. Those related as a spouse or by adoption inherit only a life interest, which by definition cannot be passed on to their children. So the relevant part of the bill is that which is called Part 3, introduced by Clause 9 of the bill, and I refer honourable members to the proposed new sections 23, 24 and 25. So the effect, so clause 9 inserts a new section 21 that prohibits disposal of any beneficial interests in the trust property other than in accordance with the new sections to which I've referred. The new section 23, disposal by will. The new section 24, which deals with intestacy, and a new section 25, which deals with the issue of gifts. And the effect of the bill will be that a beneficiary may dispose of his or her beneficial interest, whether by will, intestacy or gift, only to a lineal descendant of Wiperi. Lineal descendant is defined in the bill as a person who's a direct descendant by blood. And so the beneficiary's spouse, child or descendant, if not the lineal descendant, is eligible to succeed only to the life interest. And so I needed to give some thought as to whether the bill discriminated on a prohibited ground, and must say I spent quite some time thinking about the issue, because as a general principle, treating adopted children differently from non-adoptees gives rise to a prima facie family status discrimination issue. However, in the particular context of the bill, I consider the different treatment the different treatment was justified and not inconsistent with Section 19 of the Bill of Rights Act. In forming that conclusion, I had, sir, regard to the essentially private character of the trust. The trust succession arrangements are very long-standing, as the previous speaker said, and are the means by which the trust seeks to preserve its tikanga. Were the trust to be created by deed today, it would probably contain exactly the same provisions and be consistent with the Human Rights Act and the Bill of Rights. The fact that the terms of the trust are set out in legislation necessarily engages the Bill of Rights, because legislation is an act of the legislative branch. But having thought long and hard about it, in my view, does not on balance obscure the fact that in substance the trust was and remains essentially a private one. So, sir, I thought I'd bring that issue to the attention of the House. It is a very important issue. In a sense, I'm giving what could be called not a Section 7 report, but it's a very important issue, and I want the House to know that as Attorney General, I gave the matter a lot of thought. In my opinion, the bill exemplifies the difficulties in reckoning with matters of indigeneity and ethnic identity in legislation. Generally, it's preferable that iwi, hapu and whanau determine their own membership in accordance with tikanga Maori, and that the state not impose a non-Maori worldview. Where legislation is used to define rights as between or within various iwi, hapu or whanau, such as through treaty settlements, any apparent inconsistencies with fundamental human rights have to be shown to be reasonable and justified. And I believe they are in this instance for the reasons which I have endeavoured to explain to the House. And if people are interested, I can advise them that there's a comprehensive coverage of this point by me, which is on the website of the Ministry of Justice in an opinion dated 27 July 2015. So with those brief comments on only one aspect of the bill, I commend the bill to the House.